welcome, Lynn Malinoski,
Thank you.
to OTW podcast series. It's great to have you today.
Yeah, thanks for inviting me. I always joked around with some of my friends. I really want to do a podcast one day, and so they were laughing at me when I said I'm actually doing a podcast.
All right. So will this be your first podcast then?
Yes, it is my very first podcast.
All right.
Yes.
So Lynn, the reason that I reached out to you and asked you to join me on this today was because there's been a long history of successful entrepreneurship within the orthopedic and spine surgeon world. We've seen lots of examples of surgeons who've started companies and developed products that have turned into companies and sold IP to other companies. And so I think it's really valuable to hear from an expert on, the pitfalls, what should we be looking for? What are the considerations when a surgeon has an idea or has a concept that they think could become a product? So before we kind of get into all of that, it'd be great if you could just kind of walk us through your fascinating journey in your career and how you sort of landed where you are now, an expert in all things IP and strategy related to that.
Okay, so I've kind of had a twist and turns along my journey. So I I graduated with a BS in chemistry, and my intention when I was in school was that I was going to go to med school, and so I was marching down that path, getting ready to go to med school. And that summer before I was supposed to go to med school, I was like, "Wait a second, do I really, really want to do this?" And it was one of those aha moments, and I'm thinking, am I doing this for me, or am I doing this because all along when I was younger, I said that was what I wanted to do? So I decided to say, okay, time out. Let me take a break and actually figure out what I wanted to do. So what I did was I ended up working at SmithKline in pharmaceutical research for over 4 years. Quickly learned that I did not want to spend my life in a lab and going for my PhD in chemistry, spending it in a lab. And it was like, okay, what next? And so I had a great mentor when I was at SmithKline. And he said, did you ever think about law school? And I said, no, never really thought about it. And I started investigating it, talking to a bunch of people about it, and quit my job. And then decided to go to law school. I had an interest in doing a lot of writing, and I was always interested in science. And I was involved a lot with regulatory filings when I was at SmithKline, and also was involved with patent work. And, I was interested in the notion of being able to combine law school and the science. And I wasn't really so sure how I was going to do that. And I sort of just kept exploring, and then ultimately led me down the road into patent law.
So then, where did you first sort of get involved in orthopedic patenting?
So when I first got out of law school, I worked with an IP boutique law firm. They were very plentiful back then. Now they've all been swallowed up by big firms, but that firm just did IP law, patent, copyrights, and trademarks. And so when I was there, when I was a young lawyer, I did some work in the chemical area, patent prosecution, procuring patents with the patent office. But then I became more involved with litigation work in the medtech space. And so although my background was in chemistry, most of my career I've actually spent in the medtech space doing more of engineering type work. And so all the time that I was at my firm, we were involved with litigating medical device patents for Johnson & Johnson, the various companies within Johnson & Johnson, and for Boston Scientific in the cardiovascular space. So that led me down that path. And I mentioned I wanted to go to med school at some point. And I think that I found this real affinity for doing med tech work because I guess maybe that doctor was still in me somewhere, but it allowed me to kind of explore that. So it was very interesting because you got to delve in, know the products, know the science. And I always have an interest for learning new technology. So you had that ability to do that across all these various different med tech spaces because you were never just singly working in one area. You had the opportunity to work in a lot of different areas in the litigation environment.
So then you were at Synthes, or at least you did quite a bit of work at Synthes.
Yes.
Was that before the acquisition or was that after the acquisition?
It was before the acquisition. So I actually thought I would never leave my law firm. I was a partner there and I loved it and I loved the people and I loved the work. But I had an opportunity. A headhunter called me and said, "Would you like to interview for this position at Synthes?" And I said, "Sure, why not?" Our firm had done a little bit of work for them, but I was not involved with doing that. So I interviewed for the position, loved the people, loved the company, and thought, okay, I'm going to do it. It was a very emotional decision for me because I had been at my firm for close to 2 decades, but it seemed that it was the right time to make the jump. Law firm work, at sometimes when you become a partner, you're more of an admin than getting to do all the fun stuff that you used to do. And litigation became a lot of writing nasty grams back and forth to opposing counsel because you didn't give me this or you didn't give me that. And I saw the leap going into Synthes as giving me that opportunity to be able to make a difference and be more involved with really looking at product work. And so that happened in January 2009. I joined Synthes, and the acquisition that happened with J&J was in 2012. So a few years before the acquisition took place. I will say a lot of my time I spent working on the acquisition, which was quite a surprise to me, but it was interesting because my life sort of had come full circle because a lot of the folks that I had worked at with J&J when I was outside counsel were still there, and I ended up working with a lot of them after the acquisition.
So did you had to prosecute any patents while you were at Synthes?
No. So at Synthes, I was fortunate to be able to build my own team as the global chief IP counsel. And so we had attorneys that supported each of the different divisions, CMF, trauma, bio, and spine. And so the team did the nuts and bolts of all the patent prosecution work. I worked with them, but I was more at the level of helping the business teams build what was the patent strategy, right? Where should we be focusing? Where are the competitors? How should we be building out our patent portfolio so that we're creating a blocking strategy so we're keeping competitors out of those various spaces? So
Mhm.
not the nuts and bolts, but was involved to some degree on that.
Interesting. So what do you think are the biggest sort of patent myth out there when you're talking to people who think they have an idea that is worth patenting? What do you think is probably widely misunderstood about patents?
So one of the biggest things, and it actually amazes me that people, very educated people, very people high up in companies have this myth. If I have a patent, I can practice it and can do anything I want. And in actuality, they can't because somebody else may have a patent that covers your product and you would be infringing if you practiced sold your product. So one of the simplest examples I always give folks is think of a pencil and an eraser. Somebody invented the pencil, but you made the better pencil because you made the pencil with the eraser and you want to sell the pencil with the eraser and you have a patent on that. But unless you have a license from the person with the pencil patent, you cannot practice your invention. And people actually are very surprised when they hear that. What do you mean? I have a patent and I can't do what I want to do with it? And the answer is no. The product that you may make may infringe somebody else's patent.
Yeah, that's interesting. I think for a lot of us, the whole patent world is a bit of a black box for just that reason. You don't know all the other areas that sort of cross over that could impact your decision. So, when you're looking at when you're talking to a physician and
Hmm.
they have an idea that they think is potentially a product,
Hmm.
what do you tell them? What's the best advice you can give to somebody who's at that point where, is it at what point should they start to do research, to sort of explore who may have a conflicting patent, an existing patent, or possibly one that crosses into the area that they want to operate?
Hmm. So typically, if a surgeon will come, or anyone that comes with an idea, the advice is generally is that, well, why is your invention good, right? You tell me, how is it different from somebody else's, right? And they will tell you their story as to why they think it's different. Now, you don't necessarily, if you want to file a patent, you don't necessarily have to do a patent search. You can file a patent without doing a patent search. And sometimes when I was in-house, sometimes we would do searches, sometimes we wouldn't do searches. There's no requirement that you do it. You may do it from a business perspective to see if you're going to be wasting your time and money filing a patent application. So you may say, okay, let me do a quick and dirty search, which you actually can just do on Google. You go to Google Patents, you can do a quick and dirty search and see what might be out there. And somebody may be surprised at everything that's out there, right? Because a lot of things don't get commercialized. They may just be paper patents. So they can look at that and see and say, oh, yeah, somebody is kind of doing this. Maybe I would look at it differently and decide I would do things in another different way that might be different from what somebody out there has in their patent.
So before you really put paper to pencil, you're saying you really should do a patent search. And that makes sense. You want to make sure that there's some freedom, at least at the outset, that it hasn't already been locked in.
So I guess there's two things I think to look at. So you have a patent and that you have a product, right? So when you look to freedom to operate, you're looking at third-party patents to see if somebody has something that covers your product. A patent is looking at has somebody done something exactly like your idea that you've done before, which may or may not be different than the product. It could be the same or it could be different. So a search, a lot of people, I will say, go ahead and just do a search, but you don't necessarily have to do it. I don't know if that's clear. Or am I talking sort of crossways there?
Well, so yeah, just pulling that thread for me. When does it make
Yeah.
sense? When does it make sense? And when would you not go to that extent before starting?
So if I was an individual inventor and I had an idea, I don't know if I would go ahead and do a search, right? I think most people that you're talking about, they're practicing in the industry, say that, so they know a lot about what's out there. And so, what I would say is before you go to talk to a third party about it, maybe you want to file your own provisional patent application, which basically is you could just have a 2-page disclosure of a document of what your idea is, slap a cover sheet on it, and you can get something filed like that at the patent office. And then go to maybe who the third party is. Maybe the third party will look at it and say, I don't know, before I want to pursue any kind of transaction with you, I want to do a search to see if there's anything out there, right? I want to look and see, and I want to see if I want to invest the money in filing a full-blown patent application on what your idea is. So they may do a search. But I will say generally, it's not necessarily common to always do a search for a patent before you file a patent.
So that just seems counterintuitive to me.
Yeah.
Because if I'm going to put any time, I got to assume I've got other things to do. So if I'm going to take time
Mhm.
to work on a product or design, I kind of would want to know, at least it makes intuitive sense to me, to go ahead and make sure that I'm not completely wasting my time doing something that's already completely locked down by, other companies.
Okay, so then I think this is the other piece, and I think we may be mixing up patents and products. So if someone's developing a product, right, and they come to you with this product and say, here's my idea, right? I would do a search on the product for third-party patents that are out there to determine whether or not I would have freedom to operate to sell that product. And maybe there are third-party patents out there directed to that product. So then you may try to design around those patents to say, okay, well, my idea is a little bit different here. So then I'm making tweaks to what that patent might disclose for my product. And then you file the patent on that invention that ultimately ends up being your product. So there's a difference, I think, if someone just has an idea, just a concept, right? Are you going to do a search on that? Probably
Right.
not. But if you
Right.
have a product that you think that, is something that you think is worth patenting, you're going to want to make sure that in developing that product, you have freedom to operate over third parties. And then you may want to do a search to determine, what your design around might have to be if there are issues there.
Mm-hmm. So
Does that
obviously,
make sense?
yeah, I think it does. A
Okay.
couple of questions come up. We've seen these patent trolls out there like Acacia who
Hmm.
go out and they just file patents and hope somebody else develops a product. And so
Hmm.
once they go out and invest all that time and money developing a product and start to generate some sales, then we've seen those patent trolls come in and try to litigate and in some cases win. So
Hmm.
how would you, if you're advising a company or an individual that has a product concept, how to de-risk themselves, before they spend good time and money on an
Hmm.
idea that can't eventually be successful?
So if someone has a product concept, I would say you have a product concept, know what that looks like. You should do a search to determine what patents are out there so that you would have freedom to operate, which means that you'd be able to commercialize that patent without infringing on anybody else's patent rights. And it may be that there are patents out there and you look at them and you say, okay, well, I can design around this patent by taking this route and tweaking this particular feature. Or or you can do a study on those patents that are out there that would say this patent's invalid because what is in this patent was out there in the prior art before. So you kind of knock out that patent as part of the analysis and the freedom to operate. So let me just back up maybe to address this issue in the context maybe if you're in-house, right? So the way that that attorneys, the patent attorneys at Depew Synthes, and I would assume most places try to do this to work in-house, is you're hand in glove with your engineers through the whole step of the process, right? So you start with them at design concept and you're working with them through all steps of commercialization. And presumably an individual inventor should be thinking this way as well. So they have a concept. You may do a landscape search to kind of see what's out there, to see where the white space might be, so that you can understand where you might want to innovate. That's something. And then once you get to the point where you have a concept, something tangible, maybe it's a prototype or it's, more tangible on paper idea, you will do what we're talking about here. You'll do a search to see whether or not that particular concept is, you would have freedom to operate over third party patents. And associated with that is you'll find out whether or not it's patentable because you're going to be uncovering third party patents. And it may be at that point in the design process, you say, no, wait a second, we got to make some tweaks. So then you will make tweaks to what that product is. Once the tweaks are made, you may do another search to make sure that you're doing that so that by the time you get to commercialization, you know that you're going to have a product that you can commercialize free from threat of any litigation. There's never any guarantees because people may look at things differently than I do or other attorneys would, but at least then you would have freedom to operate with that particular product. And that's how the stages operate in-house. It can be very, very expensive to do that from beginning to end because you're doing searches, you're having attorneys analyze a lot of patents. And some people, an individual inventor might not want to invest that because some opinions from outside counsel in terms of looking at freedom to operate can cost upwards of 50, 60,000. If the art's really crowded, like in the spine area, you could be talking $100,000 for that. So it's something that's looked at along a continuum as you're going through the process as to what you do.
You said something back then where you said if they have a patent but it's no longer valid. When would that happen apart from an expiration?
So, so what could happen is when someone has a patent and say, oh, you find this patent in a search and you say, this patent's a problem, right? So you say, okay, no matter what we do, we're not going to be able to design around this patent. So what you will do is you will retain a search firm to do a search and say, can you please find me prior art that would have existed before this patent was filed, which would invalidate the claims of the patent. And to invalidate the claims of the patent, you would look for prior art that says what's in these claims is not new. Somebody else did it before. They did it in Europe way back and they published it. So therefore the patent's not valid because the patent is not new. Or you would find references would say the patent is obvious, which would say that, okay, well, here's a patent, but you know what? There was something very similar out there before. All they did was, swap out one material for another, or they changed made an obvious design choice, so that patent's not valid. So you would try to invalidate that patent. And you could actually do that as a third party at the patent office. So you wouldn't have to wait to get sued or go to court. You could do this at the patent office to try to invalidate a patent
Interesting.
if you
So
so
the
choose.
so the patent office doesn't do a thorough enough job that they would catch that before they issue it?
Well, I would never say that, but I think so. So there is so the patent office. Anything that comes out of the patent office is presumed valid. That's just the law. It's presumed valid. But they don't search everything, right? They search, but they miss stuff, right? And so it very well can happen. I mean, you could do, sometimes searches can cost a lot of money, but if it's a very valuable product and you're running into issues like this, you'll spend that money and you'll find abstracts that may be in Japanese, maybe in Russian, maybe from anywhere, that actually show that this particular invention was out there before.
Hmm. And that would invalidate the patent.
Yeah, you have to go through the process to do it, but yeah, you can invalidate a patent that way.
So what would the process be to invalidate an existing patent that you found to be invalid?
So there's always a strategic decision about this, right? So the whole process I just explained, right? You would work with an attorney, and an attorney would develop an opinion, which is a privileged document that's between you and the client, and said, I think this patent is invalid for these reasons, right? And so based on that, the company or the inventor can just say, you know what? Okay, I've done my risk assessment. I'm going to launch this product. Maybe I'll get sued. Maybe I won't get sued, right? And then you would fight it out in court. But the other issue is it's a strategic decision. Do you want to poke the bear in essence? And do you want to file something at the patent office to try to invalidate that patent before you even commercialize it, which is something you can do. It's called an IPR proceeding at the patent office. You can file that with the patent office, but the thought is, I'm sending signals that maybe I'm worried about this patent. So maybe this competitor is going to look at me more closely and maybe they're going to sue me. And so it's a strategic decision about what you do. But the assessment that you do on invalidity or infringement is used to, you do your risk analysis. There's, and you can, say, okay, I feel comfortable with this analysis and I'll go forward. Maybe I'll get sued or maybe I won't, but I feel comfortable I can defend it.
Interesting. So take me through the process. If I'm a surgeon and I've been working with particular products that I've seen a gap, I've seen a way to improve something demonstrably to make a better mousetrap.
Mhm.
So talk to me about the sort of the continuum, the process, and at what point in my iteration of a product do I go through each step that it requires to get an issued patent?
So if you're a surgeon and you have an idea, um, you know, if if you go, you can file what I said was a provisional patent application, which is something simple, quick, and dirty. It does not get examined at the patent office, and I generally will recommend them doing that because that puts a stake in the ground before you might go talk to a third party, right? That I had this invention, as of today, and then that puts you know before you go to somebody, someone can say, well, I did that. It's like, no, I did that. I had that filed at the patent office. I had that. And the surgeon could just proceed with that and convert it to a full, what's called a utility application, and just prosecute that before the patent office, right? They could just go ahead and do that. And it can be expensive to do that process. Or alternatively, they could take that invention and approach a third party. And so I don't know if your question is if they're doing it on their own or,
On their own.
when would they
Yeah.
go
Let's
when
say
on
they're
their own? Yep.
so let's advise them. Let's say you're talking to me and I have this idea. Obviously there's risk capital that I'd be willing to put out. But there's
Hmm.
probably a point at which I'm going to say the risks outweigh the benefits. So there's little thresholds where you reach where you say, okay, if I'm going to go to the next step, I'm going to have to spend a lot more money to go to that next rung on the ladder. Walk me through the typical process that you would advise someone who has some IP in their head, maybe on a computer somewhere. How do we
Mhm.
help? How do we advise them to make sure that before they've spent $250,000 to find out that they can't move forward? How do we do that?
So the first thing I would say, I would recommend filing a provisional patent application, right?
Is
And
that
as I
something they
said,
do by themselves? Just go online and
they could do it by themselves, yeah, or they could get an attorney to do it. But it's relatively inexpensive, especially when you're individual. The patent office has fees that, it's a company fee, a small entity, and a micro entity. So when you're an individual, it's less expensive, and that doesn't have to be anything fancy. You know, it could be just, written out on 2 sheets of paper. They could slap some figures on it, draw that, and file that. And so what that does is that gives you your place in line in terms of being the first to file, right? So you have that. So within a year's time from filing that, you have to make a decision whether you're going to file a full patent application, a full utility patent application. So I recommend filing the provisional, because then as you're working on that during the course before this year happens, you could keep filing provisional applications as you're improving on your idea. And then when that year date hits, if you see the value there to that, um, go ahead and you file this full blown utility patent application that would combine all your ideas from that past year. But it's important to at least get that first application on file, so you sort of, that's your T0. And then you can keep working and combine that into a patent application. Then you go through the whole examination process. And unfortunately, it takes a long time. So if we're talking about filing the original application, if you're using an attorney, which I would recommend for doing something like that, you're probably talking between $15,000 and $20,000 to convert those provisional applications into a full utility application. Depending on the art unit you are at the patent office, so if we're talking about mechanical inventions, it could be anywhere from 3 to 5 years to get something out of the patent office. And in fact, you may file that year date may come and you file it. And it may be 2 years before you hear anything from the patent office, because nothing is happening. It's just sitting there. And so when you finally hear from the patent office, they'll generally say, we're not going to grant this patent. We think it's not novel, which means it's not new because of all this prior art we found, or we think it's obvious for all this prior art we found. So then you have to go through the next step of responding to the patent office to address all their arguments. And that, costs more money. I'd say probably between $5,000, $8,000. But if you think you're getting close and the arguments are, the patent office's arguments aren't great, and you think you're getting over those arguments, go ahead and do it. But in concert with your attorney, you should be talking about, does this make sense from a business sense, or am I just like beating my head against the wall? And a lot of times you'll have an examiner who just has their heels dug in, and they're not, I hate to say it, they don't get it, right? And so instead of doing these things back and forth on paper with them, you get on the phone with the examiner and talk through these issues. And there's a lot of ways that helps move things along, because you answer questions in real time and can address it, and you get over those humps and over those rejections that the patent office is making. And and hopefully you'll be successful. But I mean, there's no bright line as to when you say, okay, stop. It's like, I think when you get to the point, the person and the attorney has to look at what the patent office is saying, and it's like, I think we're beating our head against the wall here. There really isn't anything here. Is there anything else different? Do you think there's anything else you can change? Anything, then you just pull the plug, right?
I see. So I have a provisional patent, and then, 6 months in, I have some new ideas to enhance that. Do I go
Mhm.
back and find the original application of the provisional and then adjust that, or do I have to create a new one? And does that negate the first, or does it add to the first?
So you would generally file another provisional, and it doesn't negate the first. So when you came to that year date, you would combine all of those together into one application. And the importance of the date is it relates to what might be prior art against your invention, right? So that's how the dates become important. But you could file a provisional a month until you get to that 1 year period and then combine them all together. Or if you think it makes sense based on what the content is, you could split it up into separate applications, but you could, combine as many as you want into a single application.
What are some of the most common mistakes that people make in this process?
So I would say the mistakes people make is maybe not filing early enough, right? So I think a lot of times people think, oh, it's not good enough yet. It's not quite ready for prime time, so I'm going to wait. And I think that's not the best practice to do. My recommendation is always file it, because you could keep on improving on it within this year period. And the importance of filing is you have that date, because the law is first to file in the US as well as around the world. So I think, if you have something, it doesn't have to be perfect. Just, get that time stamped from the patent office that you had this one, and then just keep working on it.
Hey everyone, TJ Halverson here. Did you know that a mediocre hire can cost your MSK company over $1 million? While other recruiters coach candidates to say what you want to hear, we find leaders that actually deliver. The DeAngelis Group has over 25 years of transparent executive search. So de-risk your next hire by contacting us at orthospinesearch.com.
Yeah. So in the last 5 years or so, software has been kind of taken over in a lot of respects. A lot of enabling technologies that leverage AI and things like that. And there's been the Alice Law, which sort of stands for some time, that says that a lot of software algorithms aren't patentable. But now I'm starting to see some IP issued on some software platforms. Is there a distinction between what is patentable as a software and what is not patentable?
So if you think about Alice, so like software, just algorithms, mathematical equations, that kind of stuff is not patentable. And to simplify, the reasoning behind it is that a human could do it, but it's going to take a human a really long time. All that software allows it to do is to get the answer a lot faster. And so that's sort of the reasoning behind why you can't patent certain of those things. Software can be patentable when it's connected with something that's tangible and that is producing a tangible result. And so whether that's some of the languages is that it's a mechanical transformation, but that it produces some sort of tangible result. So it's not the software on its own, it's how the software is actually manipulating hardware to get a certain result.
So are there different classifications of software as it relates to software, patent like method or otherwise?
So I'll say, one of the things, so a lot of times when I talk to clients about software or inventions that we're talking about now, is that I think it's always a gut reaction that I should be looking to get a patent on something, right? So sometimes if it's software that's driving a process of some kind, you may not want to file a patent on it. You may want to keep it as a trade secret, because to file something as a patent, you basically have to disclose everything to the patent office. And you may not want to do that. You may want to keep that secret. So that's something that you may want to say, maybe I don't even want to file a patent on this particular subject matter, and I'll keep it to myself. In terms of categories, give me a little bit more info so I can tease out the answer.
Oh, I've heard the term method patent versus.
Okay. Okay. So when you talk about patents, you can patent a lot of different things, right? You could patent obviously chemical compounds, chemical formulations, pharmaceuticals, devices. You can patent methods of making something, methods of making some widget, methods of treating a human, at least in the US. Again, when you're talking about method patents, a lot of times I step back and say to clients, if looking at this device, somebody could figure out how to make it, then maybe you file a patent on it because they could figure it out anyway. But if somebody can't figure out how to make it, don't patent it, because you have yourself a competitive advantage as to how you make that product. And I think with talking about methods, I think that's a really important consideration. I think the gut reaction is always to file a patent on it, which is not always the right decision.
So when we start talking about AI, certainly we're seeing an impact across every industry, and likely
Hmm.
you're seeing it also in the legal industry. I'm just curious to what you think, sort of the risks of using AI, for example, to create a patent application, or what are your thoughts on that? Because I think a lot of us are looking for ways to streamline and cut costs where we can. Um,
Hmm.
there's always risks when we do that, but maybe you can elaborate a little bit upon, what a potential mistake might lead to in terms of cost downstream.
So one of the things that when you file a patent application is, let's just and I'll throw out a medtech example, right? Let's just say we're filing on something simple as a plate, right? A titanium plate. So you'll draft your application up, I'll direct it to this titanium plate. But, that has value, but the value is in thinking outside the box and brainstorming around what that might be. So when you talk to your inventors about this patent application, you want to get the broadest protection possible for it. So okay, the plate could be made from titanium. What else could it be made from? Stainless steel, cobalt chrome. It could be made from PEEK. It could be made from ultra high molecular weight polyethylene. It could be made from allograft. It could be made from this. So one of the things you always want to do in your patent application is sit down and brainstorm it. How am I going to design around my invention? And try to capture all of that in your patent application so that you're preventing people from designing around your invention because you have that captured in your disclosure as to what your patent is. Um, that's one thing I think you could miss with AI because maybe maybe it won't capture that live brainstorming about how you're supposed to think about your invention so you can block out your competitors and think about how you might use this differently in what different applications. And so that's one of the the downsides that I see. And I actually haven't tried having AI draft a patent application. Maybe it would do that, but I think you can't there's not a substitution for that really brainstorming and understanding all the technical aspects and making sure that is in the patent application. Because in a patent application, you don't just simply describe it, you have to teach somebody how to make it, teach somebody how to use it, have all the parameters in there, what the various ranges might be for materials and what those particular materials might be. And I don't see that AI would do that. But again, I haven't done it, but that's just I don't think there's any substitute for that sitting down and really doing that brainstorming with the inventors about, how would I design around my patent? And let me put all that in there so I prevent others from really doing that.
So it sounds like if someone has an idea or a patent concept, you like to talk to them about what's the full scope of its use, and you try to address from every angle how you can sort of layer on some complexity to that patent. Is that what you're saying?
Yeah. So because you want to be able to, expand it out as much as you can because, the disclosure, the whole patent document, you have everything in there so that later on when you're prosecuting patents before the patent office, you can get claims that cover all those different various aspects. And maybe your competitor missed your patent in their search and they think, oh, I have freedom to operate, and you say they think they were getting around it by making it from cobalt chrome, but they're not, because here's my patent and then I could draft patent claims around that. And so you really want to sort of blow it out as much as you can so that you can give yourself the broadest possible coverage.
That makes sense, so that they don't take your concept and then just slightly tweak it, and then rip it off.
Mhm.
Yeah.
Yeah, exactly. That's why, putting in ranges for various things where that's relevant, and it's like, oh, it can be, non-rectangular. So what is, instead of saying just a circle, well, I'm going to say it's non-rectangular, and then I'll say it's elliptical, it's oval, it's this, it's that. So you sort of scope all that out so that you're not in any way limiting yourself. So you're really blowing it out to get the best protection possible.
Yeah, you want a maximum scope of design such that any
Hmm.
any slight iteration that someone might try to take on it is covered under your patent.
Yep, that you can get it. Yep.
Yeah, that makes sense.
And there's one other interesting thing about patents. So, like I said, the claims are what measure whether somebody's going to infringe it. But let's just say you're prosecuting your patent at the patent office, and all of a sudden a competitor does come out with something that you don't have in your patent claims that are then pending. You could just go ahead and file claims that directly cover that competitive device, and then once that comes out, you can sue them for infringement if you so choose. People think that's a little bit mischievous or nefarious, but it's perfectly normal to do.
So you're saying that you have you've got a do you have to have a patent to do that, an issued patent, or are you
To
gonna
sue
put it?
somebody, you have to have an issued
Yeah,
patent.
but
Yes.
okay. So you have an issued patent, and then you can go back and then tweak it, even after somebody else has launched something that's on the market that
Yeah.
infringes.
If
If it
you
looks
have
similar.
support for it in your spec, right? So let's just say, they came out with the oval, right? And say, my claims that are issued right now don't have oval. I'll go back and get claims that have oval. The only key point is you always have to have something alive at the patent office. And so what that means is once a patent is granted, don't just say, okay, good, I got one patent, I'm happy. You file something that's called a continuation. So you always have something that's there that you could then add on as competitors come on the market. And really from a value perspective, when third parties are looking at individual inventors or smaller companies, they want to know that they're going to have the ability to shape
Hmm.
patents as they're moving forward. So they want to make sure that the target that they're acquiring has pending patent applications at the patent office.
Mhm. So what approximately could someone expect, an inventor, an individual, expect to spend to get an issued patent? We know it takes 2 to 5 years to get it issued, but what can one expect to pay?
So, like I said, in the US, to draft a patent application with an attorney, your formal patent, it'll be between $15,000 to $20,000. And then as you go through this patent prosecution step, sort of the arguing back and forth, that can cost you between another 10 and 15, depending on how that is. So, let's just say we're at 35, right? So I would say between 35 and $40,000. And so the US, though, is not the only game in town, right? So I think you have to decide, am I going to file my application OUS? And so there's a process where you can do that. It's a simplified process. It's called a patent cooperation treaty, where you file a single patent application outside the US. It gets examined, and then you decide what countries that you want to go into. And that's when you start talking big bucks. And so over the life of a patent, a single patent, US and international, not every country, but your main ones, Switzerland, Germany, France, Italy, UK, China, you may be talking $250,000 for a single patent. And the reason is not just the cost of getting it, but it's the cost of maintaining it once you get it. Outside the US, the fees are very expensive.
Hmm.
And that's why you want to try to get somebody else to do it for you, if you
Yeah.
can.
So let's say I have an issued patent, but I've not done anything with it. And yet I find one of the big companies has launched a product that clearly infringes upon my patent. What kind of advice,
Mhm.
what kind of advice would you give me on how to handle that? How early would you intervene? Would you want to let them kind of build that market up and get that product to have some significant sales and then swoop in and make a claim? Or would you enter in early and try to get a licensing deal with them?
Yeah, so there's two ways to look at that. So again, it goes to one of these poke the bear things too. So a lot of times what you'll have, you will the patent inventor will talk with their counsel and say, okay, here's what I found. We think they're infringing. What do we do? And so the question is, well, do I write them a nasty gram, right? And say, I want to bring your attention to such and such patent in connection with such and such product. You can do that. There's a risk there that third party will then file something with the courts called a declaratory judgment saying, we don't think we infringe and we think the patent's invalid. So you're sucked into a lawsuit right away.
Hmm.
And that might not be something that you want to be sucked into because they're very expensive. So usually I will say pick up the phone and talk to the person if you think there's, you know, if you think there's value there. The question whether you wait or not, you know, you may want to wait and see how it turns out. But your limit is basically 6 years to wait based on the law. Once that, you know, it said, oh well, they said it's okay for me to do it, so you just go ahead and do it. So there's a couple of things though when you are a non-practicing patent entity. So, and it goes to the point I think you mentioned license, right? So if they approach them, that even if they went to court, the only thing that they would get from that third party on infringement is a license, a royalty rate, because you can only get lost profits on products if you're actually selling and competing in the market. So it's probably not something that you would want to go ahead and sue them on right away, because your remedy is going to be damages, but the damages are going to be limited to royalty damages because you're not competing in the market with the product. So you know, that's the big money when you're talking lost profits. And so what lost profits basically says is, but for the bad guy on the market, I would have made the sale. And if you are not selling products, you don't have a chance of getting lost profits. So you're really boiling down to a royalty rate. And the other issue is since you're not practicing, the risk of getting an injunction against that third party is slim to none. It's difficult to get injunctions in the medical device space generally, but if you're not practicing a patent, you're definitely not going to get an injunction.
So how do the patent trolls extract so much money from the companies that they own patents that have been infringed upon?
See, they can't get injunctions, but they get royalties, right?
Okay.
And that's what happens. Actually, when the patent trolls came out, you know, so many years ago, that was their big hammer. I'm going to sue these people and I'm going to get an injunction. And that the law actually changed based on their activities. You know, relating to injunctions, the standard changed. And so they will not get an injunction. So that's a big hammer, you know, if you're going to get an injunction. So people are willing to pay. So that's not the case anymore. So it's generally that you're going to get a royalty, a license fee. And so if it's, the hopefully the company that's coming out with this product did their due diligence and did a search to know that so-and-so has all these patents that may be coming after them. But, you know, it's, you know, if they have valid claims, they could come after you and extract a royalty.
And would that royalty go back to $1?
So the royalty could reach back in time. Yes, you can go back in time. Yeah.
Okay.
Well, there's a limit. So when the patent, you know, you have to look at when the patent issued, right?
Sure.
How far the royalty would go back.
Yeah. Interesting. So you recommend then if they see somebody exploiting one of their patents to just pick up the phone and call them?
I would always call it. And so, I mean, you know, most of these people will have, you know, maybe I'm being too general here, but, you know, most people have this is like, you know, in some ways it's a small industry. If we're talking about, you know, in this space, they must know somebody somewhere, right? Or they know an attorney who knows an attorney at some place who could pick up the phone and just call. I mean, I've done that for folks, you know, and others, I'm sure, you know, that others have as well that I know. And so that's generally the way to do it. And you get a dialogue going about it. And, you know, instead of being too aggressive, because as I said, you can get yourself pulled into a lawsuit you don't want to get pulled into.
Yeah, for sure. So what a lot of surgeons will do is they'll sort of socialize an idea to the strategics and
Yep.
see if there's any interest. And sometimes that can be risky. So what advice would you give to a surgeon that has an idea or a concept, or maybe it's further along and maybe they've got a provisional patent, but what kind of exposure do they have, and what advice would you give them to prevent that exposure?
So I think, and you already mentioned it. So I said the first thing I would do is make sure you have a provisional, so you have that stake in the ground as to, you know, this is mine before you go in to talk with them. Again, I would make sure you had an NDA in place, and so that whatever is being, you know, disclosed is protected, and that there's a, you know, a significant enough term on that NDA in terms of, you know, how long the confidentiality period is. The other thing is that, the people who know the field the best are the ones who are working in it day to day. But those are generally people you don't want to be talking to about your idea, because I think not that anyone's going to do anything nefarious, but you have to separate these things in your brain somehow. And so if a surgeon's coming and talking to somebody who's developing, I'll just use the plate example again, right? A plate with a different kind of locking hole. So you don't want to disclose it to that engineer who's working on it. You want to disclose it to somebody else. Maybe they're within the trauma team, but they're in a completely different area. Or maybe you get somebody from the spine team, somebody else to disclose that idea to, or you have the business people. But you want to be careful because it could happen, and it has happened. With a lot of companies where they've gotten themselves in trouble because they've disclosed, things were disclosed to the wrong people, and it travels down the lane, and they come out with the product. Globus had a lawsuit against them several years ago, and they got hammered
Hmm.
on a situation like that. So you have to be very, very careful about that.
Can you describe that situation and what happened?
So the case was a Dr. Bianco, and he had disclosed an idea to the company. Now, apparently, there's disputed about whether it was confidential or not. But I mean, I think anybody who's has good business practices knows that there's expectation of confidentiality. But I would always make sure I had something in writing. So this idea, it was for a cage. A spine cage, got communicated to various people, and ultimately the doctor was written to and said, "Oh, we're not going to pursue that idea anymore." Well, lo and behold, several years later, there comes out an idea that's very, very similar to the design, and he sued them, and he won. I don't remember the exact numbers off the top of my head, but there was a lump sum in damages, as I recall, and then also an ongoing royalty to the doctor because of that.
Mhm.
But you don't want to be in that situation, right? You want to make sure that you're protected going in, and just to set up those guardrails, and the surgeon should ask the questions, right? Well, I want to make sure I'm not talking about this with the people who are working in this identical field in this space. Could we make sure that's not going to be the case, just so that they're protecting themselves?
Yeah, that's a challenge. I could see where, you'd want to talk to the people who know the most about your product.
Mhm.
But if that exposes you to more risk, then that's clearly a challenge.
There's different levels within, tiers within the product development. Some you talk to maybe that someone who's leading a larger product development team who's not in the day to day on the weeds, but they know what the overall strategy is that will help you. But it's the people in the weeds where you get yourself in trouble.
That's good. Yeah, that's good insight. So obviously NDAs are really important to make sure they get signed before you're getting into the weeds on your product. Are companies generally
Yep.
good about being willing to sign an NDA with a designer?
So I will say sometimes companies will say, well, only disclose to me non-confidential information. I don't want to do the NDA. But, that'll be a very brief discussion if that's what happens. And I think the surgeon has to be very careful if they're being pushed that way, to be very, very careful and talk in very, very broad strokes. But I will say most companies will sign an NDA. Because you want to get the detail. You can't make a decision based on that, and so you want to make sure that you're getting the information. I would insist on it, right? Because it's difficult to convey your idea most times without discussing the confidential information, right? And you don't want to get into that situation where you slip things up.
Yeah. What are some of the toughest lessons that you had to learn in that regard?
So I think this happened in one of our European companies, is an issue about, and it became public, so I'm not telling you any secrets, is, an NDA. It was a very similar situation to the Globus matter, where there was a dispute whether or not there was a confidentiality agreement in place, right? And in Europe, there's different issues that come up because they're a civil law country versus a common law country, like than here in the US. So there's arguments there about that. But again, it's always, don't mess around. Just put an NDA in place, and the NDA protects you in a couple of ways too. Is that granted, you may have a provisional patent application on file, but anything that's a non-confidential disclosure, you can create prior art against yourself. And I'm not going to go down that path because it gets really complicated, but I think you have to be very careful about creating prior art against your own invention.
Can you elaborate on that a little bit?
Yeah, I could. So I think so. Let's put ourselves maybe separate from a formal meeting with the strategic. So let's just say, there's a doctor at a meeting, and he sees somebody, and he's like, "Oh my God, I have this great idea. Let me start talking to you about it." And they start talking. They're sitting down at the board. There's drawing stuff on napkins. They're doing all this kind of stuff. May not think of it, but that's actually a public disclosure of your invention. And that could be a bar to patentability of your invention.
Really?
So it's careless talk about anything out without any constraints on it that's about your invention before you have something filed can be a problem. That's a lot of times, surgeons will be going to a meeting and they want to put an abstract up. It's like, don't do that unless you have a provisional patent application on file, because you're creating prior art against your own concept. And so it's things like that you don't think about, but they can actually create prior art and hurt you in the long run in terms of getting a patent on what your idea might be.
Wow, that's really great advice. So just kind of in wrapping up, I would say, what advice would you give, Lynn, to surgeon who's working on something that he thinks will be differentiated, or but kind of weighing the costs of going down this IP route? Help give some advice to that individual on how to make the most of this opportunity that they might have before them, and de-risk it at the same time.
Yeah, so I think what I would do is, if I was a surgeon with an idea, I would definitely talk with an attorney, get a patent application filed, a provisional patent application filed that scopes out everything about what you think your idea might be before you go to talk to anyone, because then you're avoiding that prior art issue, right? And you're basically going to someone saying, "This is mine, not yours." And the further along you are in a concept, if you have prototypes and the like, that's going to do you much better when you go to approach a company, because they'll see that you have some, had some proof of concept that it's able to do, But again, as you're going down each of these steps, you're adding dollars, right? And they have day jobs. And so, they want to be able to put their best foot forward. But maybe it is they go to the strategic with the idea and let's partner on this and work together, right? And so you can enter into an agreement with the company to basically they'll develop the idea with you, right? And you can reach an agreement with them that maybe you're getting royalties at the end if the product gets commercialized, right? Or maybe you go to them and say, here's all this I have, and people think it's a really great idea. Maybe he just sells that to them as a complete asset, right? And maybe he gets a lump sum payment, or again, the asset purchase could be, once it's commercialized, he would start getting royalties, which is probably more likely because then the risk is more balanced on both sides of the transaction. But I think, he's not going to be able to do it on his own. You have regulatory, you have testing you have to do. You have to do, validations, manufacturing, doing all that. That's just really not feasible. So I'd say find the right partner and find a champion within that partner. You must know someone, or someone who knows someone, because you need to get to the right people within there to be able to get the idea, vetted, right? To it actually get to somebody. I mean, that's one of the most important things. You have to get to the right people, so it doesn't just sit there. And you have to get to someone who's pushy, right? Because otherwise, if you don't, it's not going to march up the ladder, like it has to.
Yeah, boy, great advice. Really, very insightful, and I think it really speaks to the real value of having an expert such as yourself to help navigate that risky terrain. So thank you so much for taking the time to just share some of those thoughts with us today on the podcast. Now, if listeners want to get a hold of you, to learn more, or maybe explore ways to, partner with you and have you be their advocate, how would they get a hold of you?
I want to give you one last tidbit before I do that. So although I said when you go to a company and you have an NDA, you disclose your idea, but do not start inventing with them. Do not start brainstorming, because you together with that whoever that is might say, oh well, I might do this with this, or I might do that with that. Then you have an issue where you're inventing and you might lose ownership of it because you had people from inside make contributions to that idea. So an NDA, I always say an NDA is like dating. You only give so much information. Once you're engaged, that's the agreement. Then we're talking, and you're married, you're married, and you're talking about, okay, we own this stuff together. So you want to be careful how much information you give away and what kind of things you do with the company once you get there. So just that one last tidbit, because I find that happens a lot with people, because you have a lot of smart people in a room and they're all saying, well, why don't we do this? Why don't we do that? And it's like, no, this is not the time to be doing that. So that's one of the most important lessons learned that
Wow.
folks should appreciate.
Yeah, I've actually I've seen that happen, and it's a rude awakening to find out that you now co-own that IP.
Hmm.
It's not
Yeah,
yours
and that's not a good situation. Yeah.
it's now ours, not not yours.
Hmm. Yeah.
Uh,
And yeah, you don't want that to happen.
no, that's really great. So there are some pitfalls, and there's some real treacherous potential waters if you're not prepared properly. And so, gosh, I kind of came into this conversation thinking, wondering if AI was going to supplant the IP attorneys, but after this conversation, I'm pretty sure you have some job security. So,
I hope
uh,
so. I mean, you read about AI is going to supplant all the white collar workers, right? So that's like
yeah,
all of
yeah.
us included. So yeah,
So
it's
how do we
scary.
how do people get a hold of you, Lynn?
So I do have a website. It's ipstrategiclegal.com. And my email is lynnmalinoski at iplaw.business. That's a mouthful, but all this information is on my website.
All right, we'll make sure that we put that at the end of this podcast in copy so that they can just click on it or find it easily transferable. But really great conversation today. Appreciate your time and your expertise.